Welcome to Spoken Injustice, where we put the criminal justice system in the dock. Today we take you to the heart of a powerful protest that took place on the 30th of May 2025, right outside the offices of the Criminal Cases Review Commission, CCRC, in Birmingham. In a renewed effort following last year's demonstration, campaigners, families and individuals who believe they have been wrongfully convicted gathered once again under the banner of the innocent failed by the CCRC. Their message was clear. The CCRC is failing in its duty as the last line of hope for those seeking justice. The protest was organized by the Jeremy Bamber Innocence Campaign, JBIC, and it wasn't just a repeat of last year's event. It was a reflection of the growing momentum behind a movement demanding urgent and meaningful reform. The afternoon began with Philip Walker, director of JBIC, who reflected on how things have changed in the past year. He pointed to several key developments: the resignation of CCRC Chair Helen Pitcher, the release of the Henley Report, and the Law Commission's proposal to replace the long criticised real possibility test, a test seen by many as a major roadblock in getting cases referred to the Court of Appeal. While these changes might seem encouraging, Walker asked the big question: will they actually lead to timely, independent and thorough investigations for all applicants? His message was clear. This is not time for complacency. The pressure must continue if the CCRC is to fulfil the purpose Parliament intended: to provide hope to the innocent. Among the powerful voices on the day was Michelle Bates, sister of Barry George, who was wrongly convicted of the murder of TV presenter Jill Dando. His conviction was quashed in 2007 and he was acquitted in 2008. Michelle, also a patron of JBIC, called for a reformed CCRC or an entirely new body, one that is truly independent and committed to justice for the innocent. Michael O'Brien, who served 11 years for a crime he didn't commit, 7 of those alongside Jeremy Bamber at Long Lartin prison, focused on accountability. He highlighted a shocking truth: not a single police officer in Wales linked to miscarriages of justice has been held accountable, and in England only 3 officers have faced consequences, despite an estimated 85,000 miscarriages of justice since 1989. His message: without accountability, this cycle won't end. John McGowan, also from JBIC, delivered a passionate speech quoting Paddy Hill of the Birmingham Six, one of the men whose wrongful conviction led to the creation of the CCRC itself. John echoed Hill's words, calling the CCRC a whitewash, but ended on a hopeful note: our day will come. Support was also shown for Lucy Lebby, another high-profile applicant awaiting a decision from the CCRC. Christopher Logan, founder and chair of the Yellow Butterfly Group, which has been quietly and respectfully campaigning for her right to a fair appeal, made an emotional plea. He said to hold her back longer than necessary is a day less she has to reclaim what was so wrongfully taken from her. Nicky Rowley, the lead organizer of the protest and member of JBIC, spoke on behalf of Robin Garbett. Convicted of murdering his wife in 2011, Robin, a post office sub-postmaster, has always maintained his innocence. Central to his case was the now discredited Horizon IT system, which the prosecution cited to suggest discrepancies in the accounts, a claim they argued provided and motive. His application to the CCRC is still pending. Emma Morris added another powerful moment, sharing how she has written to Karen Nella and Amanda Pierce, senior leaders at the CCRC, inviting them to attend the protest and hear directly from those affected. Disappointingly, no one showed up. Their absence spoke volumes about the CCRC's attitude towards those fighting to prove their innocence. Emma spoke on behalf of John Bartlett. Two former police officers, Philip and Sanjay, also shared their insights into what causes miscarriages of justice. While acknowledging that not all police officers are at fault, they pointed to poor legal training, weak leadership, lack of oversight, and declining policing standards as key factors. But it doesn't stop there. They also cited serious failures by prosecutors, defense solicitors, and judges. Phil called for unity. Unity is strength, and shining a light on misconduct is simply the right thing to do, he said. Sanjay emphasized the mishandling of evidence and flawed expert testimony, as well as the institutional delays and inaction by the CCRC, which often fails to investigate meaningfully or challenge police even when exculpatory evidence is destroyed or tampered with. While we weren't able to capture every single speech in full and a few moments were missed, we are confident that other media outlets present on the day will help complete the story. What matters most is that the core message came through loud and clear. Reform is urgent. We must stress that the CCRC is only part of the problem. The deeper issue lies in a system that allows these injustices to happen in the first place. Prevention must become a priority. Now we bring you the speeches we were able to record, raw, powerful, and deeply human. If you believe in truth, accountability, and justice, please like, share, and subscribe. Your support helps us continue shining a light on the personal stories and devastating impact of a justice system too often blind to its own failing. Until next time, stay informed, stay engaged, and stay tuned as we continue to sit and rise in this unique trial.
Is it important to review what has happened in regards to the CCRC since we last got together here? The day-to-day operations of the Commission remain as poor as ever, with unnecessary delays, gaslighting of applicants, and little or no active investigation in cases that require it. Just some of the problems that continue to bug the CCRC's operations. But on the positive side, there have been a number of helpful developments. Firstly, some signs that the CCRC is being held publicly accountable for their performance have emerged. Helen Pitcher, who was chairman of the organisation when we last met, was rightly fired by the Secretary of State for Justice, Shabana Mahmood. Although Ms Pitcher fought her sacking tooth and nail, she was finally dispatched after a panel hearing. Astonishingly, despite being head of the organisation, she claimed that the widely accepted failures of the CCRC were nothing to do with her, and that she was being made a scapegoat. She now has more time to spend on her numerous other interests, including chairing the panel that appoints judges, which in most people's view was a clear conflict of interest with her role at the CCRC, where judges' performance was potentially under scrutiny. More recently, the Parliamentary Justice Committee has produced a report saying that the position of Karen Nella, the current Chief Executive of the CCRC, is no longer tenable. This report was partly based on the hearing that the committee held with Ms Nella and the CCRC's Head of Casework, Amanda Pierce, which highlighted the CCRC's lack of leadership and the fact that nobody who works for the organisation actually appears to go into the office here behind us more than a couple of days a month. So it is no wonder that the CCRC is floundering and meeting none of the aims that Parliament set for it when it was created in 1997. The other main development in terms of public scrutiny of the CCRC's effectiveness was the publication of the Henley Report in July of last year. This report, which the CCRC tried to alter and delay, was a damning indictment of the CCRC's failings in the case of Andrew Malkinson. The litany of faults and errors that Chris Henley KC set out in his very thorough report clearly came as a big surprise to the public and politicians. However, it just laid out all of the problems that we collectively have been highlighting for many years. So, whilst it's encouraging that these defects are now in the public domain, we need to keep up the pressure, particularly on Parliament, to rectify this situation and introduce radical reform to the way the CCRC operates. The final potentially positive development is the work of the Law Commission that is probably going to recommend to the government a number of significant statutory changes that will help the CCRC meet its legal obligation to provide a timely, independent and thorough investigation of all the cases of all applicants that apply to it. One of the key issues that they will be looking at is the real possibility test that the CCRC currently interprets in a very restrictive way. The Law Commission correctly considers that this is an unfair barrier to cases being referred to the Court of Appeal and will be recommending that the test be changed so that more cases can be referred. We obviously strongly support that proposal. So, whilst there are potential changes afoot that may improve the current situation, we must keep campaigning, not just on behalf of the individuals that we are fighting for, but to ensure that the current setup undergoes comprehensive reform so that it can provide the hope of justice to the wrongly convicted that Parliament intended. We're now going to hear some of the individuals who have suffered from the CCRC's appalling failure to do its job, which will highlight the terrible practical effect on innocent people of the organisation's shambolic performance over many years. And the first person we're going to hear from is our patron, Michelle Bates, who will speak about the case of her brother, Barry George.
Thank you everybody for being here. It's really lovely to see so many people interested in miscarriage of justice and the ongoing miscarriage of justice, because even after the CCRC, it continues, as you'll hear later. But for me, I came to miscarriage of justice in the year 2000 when my brother Barry George was arrested for the most crazy thing, the murder of Jill Dando. Now, how on earth could that happen with just a regular family? But for me, living in Ireland, my life changed forever. I always feel as well that when I talk at these things, I don't only talk about Barry. There's a whole lot of overlap, but today I actually want to mention Jeremy because I always feel that we've got a shared history, Jeremy and I. In 1985, I was pregnant with my first child and I was overdue. And I'm sure there are plenty of women here who know that feeling. Upstairs to watch TV. Take it round there. When I turned on the telly, there was a big news flash. And for anyone who doesn't know, a news flash is totally different to breaking news. Breaking news can be anything. A news flash, that's big. That's really big. Apparently there was a siege of a farmhouse. The son of the family was outside with the police. The media, they weren't allowed to fly over the farmhouse in case they spooked the person that the police were talking to inside. this person had been seen walking about in front of a window upstairs. There was a phone call answered, and then it was taken off the hook. I heard this again from the media. I waited up for a few hours, but I had to go back to bed. On waking, I rushed to see the news. 5 days in farmhouse siege. The police had stormed the property in the early hours to find nobody alive inside. I think it's important too that I mention something here. I've never met Jeremy, but I've always believed he was innocent. After all, he was outside with the police. After he was convicted, I was shocked. What did the police know that we didn't know? Over the years, as I raised a family of 3, I couldn't forget Jeremy. Nothing made sense. Then, in the year 2000, my brother was arrested for Jill's murder, as I've said, and that's when everything changed for me. I fought a wrongful conviction for 8 years. I've seen all the injustices that were levelled at him, the twisting of facts, the contamination of evidence, circumstantial evidence only, things common to all miscarriage of justice cases. After we had Barry freed, and in a slightly better place, I decided I wanted to reach out to Jeremy's solicitor. Though I really couldn't see what I could do, I was put in touch with Trudy and Yvonne. I felt that at least I could speak out, if nothing else. Jeremy knew Barry in prison. He and some of the others had set up a ring around Barry to try to stop unscrupulous inmates from setting Barry up, which they certainly did try to do. Everyone knew Barry had been set up to take the fall. So why do I go into all of this today? Well, as many of you will know, the system, I think we call it the justice system, and the public vilify anyone who tries to help Jeremy Banda or anybody else. In Jeremy's case, we are either forming infatuated females, or we are just crazy and we want a mass murderer freed. Well, this is the propaganda machine at work, trying to ensure the wrongly convicted never get heard. And now I come to the CCRC. As Philip said, it was set up in 1997 in the wake of the terrible miscarriage of justice to the Irish in the 70s. And the CCRC was held out as the last bastion of hope to the wrongly convicted. They were independent of the justice system. They were champions of the wrongly convicted, the righters of wrongs, and they will put things right. The reality is, well, the real possibility test. If we send this case through, is there a real possibility the Court of Appeal will quash the conviction? This is not independent. They are making a judgment instead of helping the miscarriage of justice victim. That's not justice. Waiting years, fighting hard, finding new evidence, to be turned down before being heard. Andy Malkinson, 17 years. Peter Sullivan, 38 years. Robin Garbutt, 14 years. And on his 4th application. And of course the whole post office scandal, well, they helped to bury Robin Garbutt. Lucy Letby, I'm so pleased to see people here for Lucy. But in fact there are so many names it would be impossible for me to name them all. So apologies to those that I've not mentioned. What I say to the CCRC is the real possibility test. Is there a real possibility this person is innocent? And if there is, push for them. Jeremy Bamber is nearing 40 years. We are not a developing world country. We're supposed to be sophisticated. The best justice system in the world? Innocent people left to rot? Reform is needed, and the CCRC, or a new organisation, must go back to being independent upholders of justice. Hope for innocent people. Thank you.
Good afternoon, ladies and gentlemen. My name is Logan, and I am the founder, chairman and campaign lead of the Yellow Butterfly Group. We are a small and private group who campaign on behalf of Lucy Letby. Now, before I get to the matter in hand, I just want to say what a huge honour it is to stand alongside all you brave warriors here today. And I also want to thank our wonderful organisers for making this possible. So thank you very much. As I'm sure most of you will know, Lucy is currently serving not one, but 15 whole life orders. 15 whole life orders. And in every single case, there is not a shred of genuine, hard evidence. Lucy was instead convicted using circumstantial evidence. Circumstantial evidence they claimed proved beyond any reasonable doubt that she was guilty. Ladies and gentlemen, I can tell you today that the circumstantial evidence used to convict Lucy had more holes in it than a string vest. Does that sound familiar to anyone else? It has been said many times now that another Andrew Malkinson should never be allowed to happen again. But I can tell you for certain it will happen again. Because the people we all stand here for today are the next Andrew Malkinsons. Andrew is not a once-in-a-century error. He is the tip of the iceberg in this epidemic. So today, I make this very short and respectful plea to the CCRC on behalf of the Yellow Butterfly Group who stand with me here today. Please refer Lucy's case back to the Court of Appeal as soon as you physically can. Lucy is in the prime years of her life now, and to hold back a day longer than necessary is a day less she has to reclaim what was so wrongfully taken from her. Ladies and gentlemen, I make no bones about the fact that my loyalties are always with Lucy. But I hope to God that if her case is fast-tracked back to the Court of Appeal, the level of scrutiny in the criminal justice system will not only bring about Lucy's justice, but the reform that everyone being represented here today deserves. Thank you so much. God bless. Thank you. Next, we've got John McGowan. Thank you.
Thank you very much. Well said. My name's John McGowan. I'm part of the Jeremy Bamber campaign. And I'd like to read to you what was, in my opinion, the best speech ever delivered outside the Old Bailey. It was on the 14th of March 1991. And it's particularly poignant considering the city that we're in. For 16 and a half years, we've been used as political scapegoats for people in there to hide. The police told us from the start they knew we hadn't done it. They told us they didn't care who had done it. They told us that we were selected and that they were going to frame us just to keep the people in there happy. That's what it's all about, to save face. Justice. I don't think the people in there have the intelligence nor the honesty to even spell the word, never mind dispense it. They're rotten. Those words were broadcast around the world, and they are, of course, the passionate words of the late Paddy Hill, erstwhile of the Birmingham Six. It's important to note that many people in this city are still waiting for justice 51 years on. As a result of the high-profile cases of the 80s and early 90s, the CCRC was set up in order to ensure that miscarriages of justice, or frame-ups, such as these would never happen again, or would be dealt with urgently. But to quote Paddy Hill again, the CCRC is a whitewash, nothing more and nothing less. Miscarriages, or frame-ups, are a thing to be brushed under the carpet, to be prevaricated over, to have mendacious TV dramas and documentaries commissioned about, in order to perpetuate the lies and travesties of sham trials, to save face. Jeremy Bamber has been incarcerated as an innocent man for almost 40 years, and nobody reading the evidence could possibly doubt his innocence. That evidence has been inside this building for over 4 years, and at the current rate of review, they're going to finish it 8 years from now. That's not understaffing or underfunding. That's simply a scandal. I know many others today are campaigning for friends and loved ones, and I wish you all the very best of fortune and strength. Never forget the cover-up is as evil as the crime. Hillsborough, Bloody Sunday, the Post Office Horizon scandal, Birmingham, Guildford, institutional sexual abuse of children. Those covering them up have blood on their hands, and until severe penalties exist for it, it will continue. I'll leave you again with the words of Paddy Hill with his interview from the BBC for their Hard Talk programme. He said, "We didn't get our convictions overturned because of the government or the courts. I'll tell you what got our convictions overturned. Public outcry. One thing about the British public is that when they see an injustice, they're not afraid to stand up and scream about it. We were put into prison to satisfy public outcry, and in the end it was public outcry that got us back out again." Friends, I wish you all good luck in your struggles to get the public aware of the miscarriage you're supporting. Night is darkest just before the dawn. Our day will come.
Nicky Rowley, and I am part of the Jeremy Bamber campaign team. But today I'm going to be talking to you a little bit about Robin Garbutt. So Jane Metcalf campaigns tirelessly on his behalf, but was not able to make it today. We have Darren Newell, who's here somewhere. Darren, yay! He and myself created this morning on the back of the t-shirt. Read you a little bit that Jane has said. So if you don't know, Robin was a postmaster who was convicted of murdering his wife, and he was found guilty in 2011. It was said that he killed her because he did not want her to find out that he had been stealing money from the post office. Now, as we know, with the Horizon scandal, that wasn't true. There was no money stolen. But the post office got involved and they said, yes, there's money missing, and that helped to convict him. There is nothing that still stands from the original trial. There is an overwhelming amount of new evidence that not only smashes the two main strands of the prosecution case, but also points away from Robin and towards several other suspects. There were no forensics, no blood, no DNA. Nothing to link to Robin. However, there was a plethora of forensics to suggest other males were involved. There was a clump of hair in the photographs left on the bed. Now, this did not match Diane, his wife, or Robin himself. This was not, as far as we're aware, taken for testing. We don't know where that clump of hair is. It is also suggested that Robin put the murder weapon on top of an 8-foot wall that evening. That is what the judge told the jury. But CCTV footage shows that was not the case. It shows there was nothing on the wall that evening, and the weapon turned up 2 days later. Even though the CCRC are aware of this, they have said that it could have been found by a member of the public and put up there, and that means nothing. So apparently the post office discrepancies mean nothing. The fact that the judge had said that Robin had put the murder weapon, he'd told the court, told the jury, he'd put the murder weapon on top of this 8-foot wall. We know that not to be true. That means nothing, according to the CCRC. 4 times they've gone back to the CCRC, and every single time they need to come with new evidence. What Robin feels about this is that the CCRC drain you of all the evidence. Just wait until you have run out of evidence, just so they continue to refuse your right of passage back to the Court of Appeal. And by listening to others here today, I think I'd have to agree with that. So, Robin's case is currently with the CCRC. Who knows where it will go, what will happen. But as it stands, Robin will continue to stay in prison and protest his innocence because he is not going to admit to something he has not done. Thank you.
Hello. First of all, for those of you who don't know about my case, my name is Michael O'Brien. I was wrongly convicted for a Cardiff newsagent in 1987 and served 11 years and 43 days because of a blatant fit-up by South Wales Police. It's as simple as that. I don't want to go into the niceties of my case because it's all online. I'm here for Jeremy today and for all the other innocent people who are still in prison, basically because the CCRC can't do their job. Now, I want to go straight into the CCRC first because I was one of the first cases they referred back to the Court of Appeal. I don't have a go at them lightly, without foundation. But the fact is, the honeymoon period was over many, many years ago, and with Jeremy's case, the Lucy Letby case, they need justice now. Not next year, not 2 years' time, now. And we're demanding that today. Now, going back to Jeremy's case, I actually was in Long Lartin with Jeremy Bamber, in Long Lartin, and I got to know Jeremy quite well, and I knew there was something wrong with his case. There was other innocent people in prison at the same time, the Birmingham 6, Guildford 4, Cardiff 3, and many others. And we all used to hang around together and stick together as a unit and used to help each other. And I knew early on that Jeremy Bamber was innocent, 100%. And I've been on podcasts, I've spoken about Jeremy's case. I am really fed up in the CCRC though. In 4 years new evidence has been at the CCRC. Justice delayed is justice denied. 4 years new evidence has been presented to them. Why haven't they had the decency or the integrity to refer the case back? And that's one thing, that's one point I'd like to say. Also, I know Helen Pitcher is gone now, but there's others who are complicit in the miscarriage of justices not being referred, and they need to go. They need to go. It's as simple as that. There's a number of them in there who don't even deserve to even look at the case, or even qualified to look at these cases. And as far as I'm concerned, we want them out. We want a new beginning. Either the CCRC are reformed, or they have to be abolished. It's as simple as that. There is no other way forward. There's too many cases of miscarriages of justice. They're still occurring, and that brings me on to the accountability. How many police officers do you think have been caught and imprisoned for wrongful convictions? In Wales, I wrote a book called The Dossier. There's 15 cases, and not one officer has been brought to book. Not one. The statistics in England are not much better than Wales. There's only been 3 police officers out of a possible 85,000 miscarriages of justices which have occurred since the Guildford story broke in 1989. That is the statistics of the Innocence Project in Bristol. Most of these are mundane appeals you don't hear about in the press, but nevertheless there's still miscarriages of justices and only 3 police officers. Unless we start getting accountabilities for these miscarriages of justices, there's always going to be more behind us. We have to stop it now at source. There needs to be some sort of judicial inquiry to look at the whole shebang, the whole lot. The CCRC are failing, some solicitors are failing, the whole system is failing. It's got to stop now. In relation to Jeremy, 39 years it is now since he suffered a miscarriage of justice. It's not on. if the CCRC got any integrity left, all I would like to say to them is, do the decent thing. Send this case back to the Court of Appeal and let the man have his life back. Thank you very much.
Hi everyone, I'm Emma Morris from the Jeremy Bamber Innocence Campaign, and I'm going to tell you a story today about a lovely man called John Bartlett. But before I do, I just wanted to let everybody know that a few weeks ago I wrote to Karen Neller and Amanda Pierce, and I implored to them to come and listen to your stories today, or a senior member of the CCRC to listen to what everybody has to say to the real life people that their organisation affects. I didn't receive a reply. And is there anyone from the CCRC here listening? No. Speaks volumes, doesn't it? In the 1980s, 1990s, John Bartlett was a professional racing driver team owner in the World Endurance Championships. He had no criminal record and had never been in trouble with the police. In the early hours of the 8th of February 1993, Met officers in a dramatic dawn raid, codenamed Operation Spider, swooped on John's Arundel home. John and his wife Mary were away, but John's 79-year-old mother Betty was living with them. As the Met burst into the house, Betty suffered a serious stroke, confined to a wheelchair from that day on. When the Met raided John's home, he was out of work following the collapse of his team and after a serious injury following a fall from a horse. John was insured by his insurers, Consolidated Marine and General, refused to pay him until he complained to the BBC Watchdog programme. Weeks later, Watchdog screened the first massive PPI expose featuring Consolidated Marine. John and his family were suddenly staked out by 6 firms of private detectives instructed by Consolidated Marine to rebut his claims. Each investigator reported John's claims appeared legitimate, with one exception: a retired Met police officer working as an unlicensed investigator for Consolidated Marine. He said John was riding horses and mucking out stables at home, proving he couldn't be injured. Consolidated Marine contacted the Met Police with their evidence, resulting in the raid. However, that former Met officer had not been watching John at all, but he'd been watching another couple who were renting John's stables. Despite realising their mistake, the Met still arrested John. After the first raid, John threatened to sue the Met, Consolidated Marine, and the credit card provider who sold him the PPI. So the Met raided a second time, this time taking his entire defence documentation. Indictments were changed and a false narrative created to complicate the case to the point a jury would get lost. During that second raid, the Met pressured John to plead guilty, saying, "If you don't confess, we may have to look into your wife's involvement. If she goes down, think what will happen to your kids. Nasty things happen in children's homes." Days later, Mary dragged John unconscious from the family's fume-filled car. Just prior to the trial starting, John's senior barrister was delayed, but the judge refused to postpone the trial start, leaving John with an inexperienced junior barrister to defend him. The barrister then withdrew days into the trial due to injury, yet the judge still insisted the trial continue in John's barrister's absence. On being found guilty, John suffered a breakdown and was admitted to a psychiatric hospital. He was then refused the right to appeal because he'd exceeded the 28-day appeal deadline while sedated in hospital. Upon sentencing, and against psychiatric advice that John was unfit to serve a prison sentence at that time, the judge sentenced him to 6 years and immediately sent him to HMP Wandsworth. The judge also made a proceeds of crime order, confiscating the will of John's late father and ordering the sale of the family home, despite it belonging solely to Mary, who was not mentioned in any of the charges. After leaving prison, the family left the UK. John wrote what was to become a best-selling book, Check of Justice. The book was produced in audio by the late Leslie Phillips CBE and Crime Watch presenter Nick Ross. A documentary on John's story is currently being filmed. In John's 2019 CCRC submissions, experts presented new MRI evidence proving the extreme damage caused to John's spine, with a broken vertebrae and flattened nerves to his legs. They were given statements confirming John's lack of defence and missing barrister, citing blatant contraventions of PACE and the Human Rights Act, proving that the Met had taken John's defence files away during the second raid, then changed the indictments, trying to damage his defence. The trial judge severely restricted evidence time for a senior spinal surgeon who was stopped from showing x-rays to the jury. The jury wasn't told about John's autism and ADHD and how it was likely to have been misconstrued by the jury when John was trying to give evidence under extreme pressure. John wasn't provided with any additional help as an autistic person during police interviews, through the trial and appeals process. The trial judge allowed Met officers to remain at the back of court listening to key witness evidence before those officers gave their own evidence. Met officers had invited the discredited private detective to brief Crown witnesses in the waiting room before they gave evidence. The trial judge ordered the jury not to be told about the discredited private detective and that it led to the first Met raid and John's mother's stroke. The CCRC was shown new evidence that Met officers had drafted witness statements themselves for key prosecution witnesses and getting other witnesses to copy them, implying that they had been written by another insurance company colleague and they were just to copy them. The CCRC was shown how multiple further procedures had been compromised and how personal agendas had got in the way of justice. They had statements from former Crown witnesses complaining the trial judge grossly misrepresented their words during his summing up, and Met officers had wrongly told them that John supposedly had a long criminal record and was a nasty piece of work that belonged behind bars. John had no criminal record, was totally innocent, and had trusted the British justice system. A highly respected solicitor, New York attorney and Crown coroner with over 40 years' experience told the CCRC, "Only 2 cases left me feeling deeply concerned that justice was not provided to my client. The case of John Bartlett is one of those." The CCRC declined to interview any witnesses and disregarded all submitted expert reports, including one from their own top forensic ASD expert who had sided in full with John's experts. They ignored reports from a senior spinal surgeon, John's former GP, and former prosecution witnesses who'd complained about how they were approached by Met officers. 3 years later, the CCRC accepted the trial judge was wrong in restricting the spinal surgeon's time, giving evidence and preventing the jury from seeing x-rays of John's spine. But they still declined to return John's case to the Court of Appeal, concluding that John's case was basically down to whether or not he acted honestly, and then quoted the highly controversial Ivy test. This legal test to determine honesty is blatantly prejudicial towards autistic people, so the CCRC concluded the jury must have decided that John had not acted honestly. The CCRC refused to confirm their sole commissioner was formerly a police officer, but did agree they would carry out a review of their handling of John's submissions. To date, despite repeated requests, the CCRC still refuses to provide a copy of that internal report. 32 years later, the ramifications of this injustice continues to affect the whole family. Both sons emigrated abroad. John and Mary continue to receive treatment and counselling for the trauma and complex PTSD caused by the trial, John's wrongful conviction and subsequent dealings with the CCRC. Thank you.
Enforcement. In fact, I worked this patch for over 30 years. Can I just begin by saying, please, not all police are bad.
Agreed.
2 names, Wayne Couzens and David Carrick, have put the police back in the spotlight for all the wrong reasons. So how do you think we're doing as a judicial system? Yeah, no one's actually clamouring to say how wonderful we are. I think, and the evidence that we have, is over the last decade we've seen the destruction and decimation of the art of policing. We've lost how to investigate with ethics and leadership. The building behind me is staffed by ex-police, which is fine if they know what they're doing and they are operating to a code of ethics, law and procedure. So I did a quick run last night and looked at my old training notes, and this is actually a very, very big learning point. If I mention the cases of Stephen Kisco, Nicky Allen, Mike O'Brien, the Cardiff 3, the Guildford 4, John Kamara, Diane Taylor, Ben Walker, he stood over there, Sanjay Ray, where are you, Sanjay? He stood there, Andrew Malkinson, Jeremy Bamber, and many, many more. So I asked the question, are things getting any better? No. So it's just some general themes from you very, very brave people. Injustice, institutional betrayal. We were all brought up, weren't we, to believe and respect the police. Lack of accountability, elongated radio silence when you want to be told what is happening with your case. Sanjay here, 2 years waited, 2 years waited, and I know he's not alone. A culture of disbelief, investigation bias, arrogance to the foundations and traditions of the law. Poor investigation has one outcome, miscarriage of justice. We have abuse of process. We have a lack of knowledge in the key aspects of the law. The Criminal Procedure and Investigations Act of 1996 is not taught, it's misunderstood, and it is abused. The Police and Criminal Evidence Act, over 192 breaches of pace in Mike O'Brien's case alone. The European Court of Human Rights, nothing to see there. GDPR, the list is endless, endless, endless. So, is this just a conspiracy theory and a facade, or actually is there something rather sinister happening? So I'm going to give you two conflicting views. So, from one Home Office report, they say, whilst impropriety was identified in a number of cases, legislative procedure and changes have eliminated or at least have reduced the opportunities for similar alleged malpractice to occur in the future. That is the state's view. A month later, we had a report from Professor Baldwin, who says, we have seen a steady and yet dramatic rise in the number of police interviews and investigations that we would call substandard, even unlawful, and grossly offensive. So who is right? My personal experience, and looking at many of the cases here today, is statement number 2. Ladies and gents, I want to hand you on to Sanjay, who will give you lived experience of his experience of mistreatment by 2 police forces. My final thoughts are, you're all extremely very brave people. Unity is strength, and stick together and keep doing what you're doing, because it's the right thing to do. Thank you. Thank you very much.
Good afternoon, ladies and gentlemen. So, as Philip said, we're both ex-serving police officers. My woes started when the Metropolitan Police DPS came after me, accusing me of misusing Met material for my registered business interest of training police officers around the world. And as Phil says, not all police officers are bad, but they have got bad leadership. and this is the slippery road to miscarriage of justice. The other aspect of it is I've recently been working on a high-profile case involving Ben as part of the investigation team for the criminal defence side of things to head off a possible miscarriage of justice by West Midlands Police that involved their senior leadership team all the way down to the officer on the ground, and also involved high-ranking members of the West Midland Fire Service and coroners and the HMIC inspectorate themselves, who were involved in trying to cover up crimes and continue to try and prosecute Ben to basically save face for the person making the allegation. We'll talk a bit more about that as we go along, but what I wanted to speak about is, and through my learning and speak to others who I've tried to help over the years with Phil and other people to evidence course of conduct behaviours on the part of individual police officers, CPS lawyers and judges, and even defence solicitors as well. And they play an important part in miscarriages of justice. So how does miscarriage of justice occur? Key failures in evidence handling, expert testimony, which is my case, one of the key factors that plays in my case that the expert lied in his evidence, and it was acknowledged by the CPS lawyer reviewing it, yet they did nothing. And also legal representation and post-conviction reviews. All these things are going to be resonant with everyone here, and have gone through exactly the same thing. So it doesn't just happen to ordinary members of the public, it happens to people who actually know what the police should be doing and have hit the same brick wall. Right, institutional delay and inaction by the Criminal Case Review Commission. Everyone has gone through the same process. Delays without investigation. In many cases, CCRC take up to 2 years or more to respond to applications. Mine is 2.5 years and counting. Mine's still current with them. And also, during that period, they may fail to conduct a meaningful investigation into the issues raised. So they won't contact you, they won't speak to you. If you flag up something to them, they'll ignore you. Excuse me. So this is the failure that's happening. And when the police tell them that they've either lost or destroyed evidence in breach of a preservation order, they ignore it. No challenge to discrepancies and factual disputes. The CCRC investigators will not challenge the police in their conduct. They will not hold them to account. They will not do anything. The other journey, that not only my own journey but others as well, police tampering and destroying exculpatory evidence and material. So pre-charge evidence destruction took place in my case, where the DPS officers breached the seize and sift powers under Section 50 of the Criminal Justice and Police Act. So what happened, even before interviewing me, they'd gone into my evidence, destroyed it, and then any hope of me defending myself and putting forward my defence had gone. And this is the police, the ones who should be upholding the standards. Manipulation of chain of custody, again, logs related to digital devices may be altered to absorb unlawful access or missing evidence. Weakening the defence strategies and corrupting the digital timeline. These are things that do take place. The expert in my case was found to be lying in his evidence to charge in. Something inside so strong.